Hi, everyone. Welcome to the second episode of Recent Developments in Antitrust, brought to you by the Monopolization and Big Tech Committee of the New York State Bar Association. My name is Chris Lynch, and I'm here today in my capacity as Vice Chair of that committee. And as the usual disclaimer, I'm not here representing the views of my employer or any clients. I'm delighted today to be joined by Professor Ioannis Kokoris, who is a professor of competition law and economics at Queen Mary University of London. Today, we're going to be discussing the latest developments in the Microsoft Activision transaction review and the latest news there. Before we turn to that, Professor Kokoris, would you mind giving us some background information about your work and your studies?
Yeah. So I'm an economist, and I've also focused a lot on competition law in UK law schools. I've been working for the UK Competition Authority for about 8-9 years in the past, and for the last 10 years, I'm an academic and a consultant on competition law and merger control issues.
Great, thanks so much. And again, delighted to have you here with us today. So why don't we turn to the transaction? And we thought one good way to do that would be to look at a timeline of where we are now and where we started in terms of this deal. So this is just a timeline of the major events that have happened from signing through where we are today. And I'll just take a few minutes to describe some of these major milestones to sort of set the table for our discussion. So in January of 2022, Microsoft agreed to acquire Activision for $68 billion. Activision, of course, is a game manufacturer, game developer that, among other things, publishes the very popular Call of Duty gaming franchise. Microsoft, of course, has its Xbox console and a number of other gaming assets. This transaction was seen as a way to sort of supercharge Microsoft's forays into gaming. So the transaction was subject to review across a number of jurisdictions around the world. In December of 2022, the FTC filed an administrative complaint challenging the deal. And the concerns about the deal have tended to revolve around Microsoft's supposed ability to post-transaction withhold Activision games from competing services. So that could be, for example, withholding Call of Duty from PlayStation or not licensing those games to sort of nascent cloud gaming services, which have been also a big focus of attention. In April of 2023, the CMA in the UK, which was also reviewing the deal, blocked the deal despite commitments from the parties that indicated that they would agree to license their games for a period of years to cloud gaming platforms. The parties at the time indicated that they would appeal that decision to the Competition Appeal Tribunal. A little bit less than a month after that, the European Commission actually cleared the transaction subject to the same conditions and commitments that the CMA had rejected. In June of this year, the FTC filed suit and the Federal District Court for the Northern District of California seeking to enjoin the transaction. About a month after that, the District Court denied the FTC's motion to enjoin the deal. The FTC subsequently appealed that decision to the Ninth Circuit, and that appeal is still pending today. Meanwhile, the parties extended their drop-dead date after their victory in the District Court. And shortly after that, the parties and the CMA agreed to pause their appeal to the Competition Appeal Tribunal to give the parties an opportunity to restructure the deal in order to address the CMA's concerns and ultimately get the transaction cleared. In August, Microsoft announced that it had agreed to restructure the deal such that it would transfer streaming rights to current Activision games and any games released over the next 15 years or so to another company, Ubisoft. And that would, according to Microsoft, address any concerns that Microsoft would withhold streaming rights from cloud gaming platforms and any other streaming and gaming platforms. Most recently, the CMA concluded that the revised deal conditionally addresses its competition concerns, and it is currently conducting a market test that is set to conclude around October 6th. Meanwhile, a few days ago, the FTC announced that it was going to resurrect its administrative adjudication of the deal before its own administrative law judge. So, Professor, I guess our first question is, the CMA is currently conducting a market test of the revised deal. What sorts of factors go into that test, and what is the CMA going to be looking for while it's analyzing the restructured deal?
So where the CMA is now is actually conducting consultation on the suggested remedies of Microsoft, or the transfer of the licensing rights, to what extent these type of commitment would address the theories of harm that CMA identified in the new deal, but also had identified in the original deal, very, very similar issues with when it comes to the substance. It will be checking in detail whether the terms and conditions of this licensing agreement and the way it will operate still leaves any room for maneuver to Microsoft to influence the incentives of Ubisoft, or to indirectly or directly impact competitors in the cloud market in the future. So we only have the headlines of what this commitment will look like, and there is a lot more small world there that the CMA will have to look into and make sure that the market is happy, that Microsoft has no room to maneuver, and also Microsoft has no incentive to adopt a conduct that will allow it to harm the competition in the market. So it's still a pretty complicated exercise CMA has to do, but the fact that it has issued it for public consultation, it's usually a positive sign that at least it has an in principle understanding that the remedy may work, but it's not certain that it will work just yet.
Do you have a sense for how typical it would be for a remedy that's put out as provisionally addressing concerns to be sort of rejected or sent back for further modification after this sort of test?
We haven't had in the UK many deals where a remedy which went out of consultation has been then outright rejected. We've had a few cases in the past where remedies were put forward by the parties, and the CMA said in the decision, or in the statement that remedies were offered, but we didn't think they will actually do it. What we have seen are sometimes cases that remedies were offered and then tweaks had to be made subject to the consultation process that took place. We have seen that on a few occasions. Got
it. Very helpful. I guess, turning to the European Commission now, as we mentioned a few minutes ago, they cleared the deal, the prior version of the deal, back in May, I believe, of this year. What effect, if any, does the restructuring of the deal have on that clearance with the European Commission, and is there a chance that they take another look at it?
The European Commission is looking at two things at the same time. It looks on the one hand at the new deal, the way it is structured, whether that deal in itself needs to be notified when it comes to the threshold that the Commission has. And the second is whether the way the remedy will operate, in the UK based, actually, let me rephrase this, the UK asked remedy will operate, because it's a global remedy, in effect, it's just global outside the EU. Right. The way the remedy that the UK CMA asked will operate, does that have any impact on the remedy already agreed with the European Commission? And according to the press release of the European Commission, they still have not decided how they're going to proceed. So they still have both options open. There was an event in Brussels as recent as yesterday where the Commission said everything is up in the air. We still have not decided how we're going to proceed. And the interesting bit about this case is this case has set so many precedents in so many different levels. It's probably one of the most important cases and one of the 5 cases in the last 40 years of EU merger control that will stay in history as one of the cases that affected the way merger control operates in Europe. So it is, European Commission can still look into this case as a new deal and can also ask for amendments to be made to the Commission's remedy, which then creates certain types of risk for the initially approved deal by the Commission.
Yeah, very, very interesting. Obviously, a lot going on and a lot of factors here. The CMA, when it issued its initial decision blocking the transaction, had sort of, I guess they had diverged from the decision that the European Commission made subsequently, and obviously the U.S. court proceedings, where the FTC lost in district court, reached a different initial outcome than the CMA. Subsequently, the CMA and the parties paused their appeal and allowed the parties to restructure it. And I think at the time, the CMA said that that decision was not influenced or impacted by developments in the U.S. Curious what you make of that, and what's your sense of the reasoning behind the developments in the UK and how they played out.
If we look at the theories of harm in the 3 jurisdictions, and we go back now 4 or 5 months ago, maybe 6 months ago, and we look at the theories of harm, they're not that different. I would say the main difference I can think of between the 3 jurisdictions is that the UK and US were, mainly the UK, were looking initially at this whole ecosystem theory of harm. And I go back now to end of summer last year when we had the phase 1 stage in the UK, and there was also a discussion in the US that they would be looking possibly at any impact as an ecosystem. Mm-hmm. We saw that the phase 1 press release of the European Commission, so when it went to phase 2, it did not really not use the word ecosystem, but it did focus on a narrower version of Microsoft operating system, along with cloud, along with the potential now addition of the game. So although there's a lot of discussion that the 2 of the 3 authorities took a different direction or assessed the case differently in substance, if we look at it, there's not that much difference. So UK CMA in phase 1 played with the concept of ecosystem. We saw in phase 2 it completely toned down the focus on the ecosystem as the theory of harm. And if it had gone all the way, then that case would be the first precedent, to my knowledge, of in a merger context, of an ecosystem theory of harm being created. So when we look at the phase 2 decisions now of European Commission, CMA, and in the US, the way the things played out in the courts, the substance is pretty much the same. So it doesn't really matter to the great extent. I think the difference between UK and EU has been to what extent UK was confident to accept an otherwise behavioral type remedy to address a problem that could not be addressed easily, at least through a structural type remedy, compared to EU Commission. And there are a lot of comments in the UK, commentaries in the UK and in Europe generally, that although UK CMA is portraying this remedy, and the parties is portraying this remedy, the UK remedy, as a divestment, mm-hmm. as a structural remedy, in effect it's a quasi-structural remedy, not a fully structural remedy. So we're still not clear whether UK CMA does consider this in reality to be a quasi-structural or a purely structural remedy. And as we know, in Brussels, the type of remedy they went for is a quasi-structural one, in effect. It's a very similar type of remedy. So at the end of the day, although this case has gone on through a lot of ups and downs, a lot of divergence at different stages between the different authorities, across the 3 jurisdictions so far, we haven't really seen much divergence on substance. So now that the FTC, as you mentioned, they brought it back to the antitrust law judge. Now, I don't think that the antitrust law judge will probably decide something different now than they did first time around. And now we also have a lot more information out there about the markets and the case from the decisions of the CMA and possibly, depending on the timing of the European Commission, if it's published on time.
Really, really interesting scenario here. Turning to the U.S., the FTC's loss in front of the district court is now on appeal to the Ninth Circuit. And one of the things that was interesting about the district court's decision was it placed a lot of weight on the previous commitments that the parties had made to license their content to competing consoles and competing cloud services, including agreements they reached with Nintendo and Sony PlayStation to make Call of Duty available for a number of years. Now there has subsequently been, I guess you could say, even more commitments or a more structural remedy available given the restructuring of the deal. So, what, if any, effect do you see this restructuring of the transaction having on proceedings in the U.S.?
I do think that there is, although we're speaking about three different jurisdictions, there is, I don't want to call it influence maybe the wrong word. There is a silent impact or a silent influence of one jurisdiction or another. So that's not the first time we see one major deal having a development in one jurisdiction affecting another jurisdiction. It brings to, sure. It jigs my memory to go back to Oracle PeopleSoft 2004, that the European Commission was about to block, and then in a stop the clock during a stop the clock process, the judge on a lawsuit by the DOJ came out with a judgment and had a few comments there on market definition, which then European Commission took into account, considered this new evidence, and changed completely the decision from prohibition to approval. So it's not the first time we actually see what's happening in one side of the Atlantic affecting the other. And possibly it's something that the parties, not necessarily in this case, I would say parties in any type of case across jurisdictions, take into account, trying to see which jurisdiction can we probably have a decision first, which can influence a possibly negative decision somewhere else. So right. I think there is some healthy and strategic part of forum/decision shopping going around by parties. So in July, we saw, we can argue it's a timing coincidence, but we saw the judgment of the district court coming out publicly the day before or 2 days before the parties CMA decide to pause the appeal. Timing-wise, it's an interesting timing. This case has been running for a year and a half, almost 2 years, and this happened only within 48 hours. Now we're having the reverse. So we're having developments in Europe, and we're having now an ongoing again process in the US. So I would expect the parties to argue before the US judge that what's happening in Europe, or at least the way that EU and UK are seeing these markets, should be reflected or should at least be taken into account in the decision or in the thinking of the process in the US. Whether it will be enough to go the different way than what we have seen so far in the US, it's difficult to tell. But we definitely have more information out there now about the potential harm of this deal on markets and these commitments which may be able to do the trick and clear this deal, at least on the European continent.
Yeah, it'll be very interesting to see, what if at all the U.S. courts, how they treat the developments in the U.K. and the EU will be fascinating to watch. I guess on a final and sort of related point, this deal now seems to maybe be heading towards a similar outcome across, all jurisdictions, but they certainly took different paths to get there. do you expect that going forward, deals that have these sort of cross-jurisdictional factors, do you expect that we'll see potentially more differing outcomes when you look at the US, the UK, and then the European Commission?
I think there is definitely more scope for divergence in outcomes now than it used to be in the past. In the past, even within the European continent, let alone between this side of the Atlantic and the other side of the Atlantic, US and EU or Europe, in the past, there was an active effort for the two authorities, major authorities at that time, to coincide on decision making. But the past had two differences compared to now. One, we were dealing at the time with, I call it more traditional markets. So these are less dynamic markets where it's set in stone in some ways how merger control is enforced. There are a lot of precedents in most types of these markets. So outcomes were more predictable, and the communication channels were more open than possibly they are now. I feel that now communication channels are not as open, which does not help convergence in decision making. Mm-hmm. They don't have to converge, but I think a healthy discussion of each other's thinking is always constructive. Also, now we're having markets which are of a different nature, dynamic, and also we're having markets where the three competition authorities now, compared to three major between Europe and US, there are other major authorities outside Europe and US, of course.
Right.
The three major authorities between Europe and US do not still have made up their mind on their own enforcement in some of these markets and how they're going to approach, for example, ecosystems, killer acquisitions, so let alone having convergence going forward.
Yeah, well, just fascinating discussion, and it will be very interesting to see what happens going forward, both on this deal and future ones. So I guess stay tuned over the next month or two. I think we'll finally get a resolution one way or another of this particular transaction. Professor Koukouris, thank you so much for joining us. This has been super interesting and very informative.
Thank you very much for the invitation. Thank you.
Thank you very much.